Yeah.
Good. Okay. Well, it's a great pleasure to be here with you this evening, and I look forward very much to the rest of the conference and also to the discussion period this evening. What do you think religion is, and what do you think is important about religion when addressing questions of accommodation and toleration? When addressing, for example, questions about the exemptions on religious grounds from forced medical treatment, or from service in the armed forces, or questions about access to meat slaughtered in accordance with halal rules, or to sweetgrass for an indigenous ceremony, or the availability of religious rights when you're getting married. Do you think of religion as an intensely personal set of commitments? Your individual sense of what is most important about life? A particular individual's personal sense of relationship to the divine, so that religious accommodation is about allowing you to pursue your fundamental beliefs without imposition? Or do you think of it as a system of governance, a system of law, separate from the Canadian legal order, controlling human conduct within our society? My guess is that for many of you, the first definition, the one that focuses on individual commitment, the demands of individual conscience, tends to be the framework through which you think about religion and about questions of freedom of religion. On that view, religion is above all an intensely personal and private matter, about the ability to follow the dictates of your own conscience. To the extent that you think about the second, about religious practices as a form of law, as a form of government, some of you may even feel uncomfortable, as though someone was having religious commitments forced upon them, or rules were being applied that did not accord with the principles of Canadian law. And you may even feel that government should be setting its face against those things, not abetting them by treating them as though they involved a form of government or a form of law. Indeed, it is the first conception, the conception that emphasizes individual conscience, that tends to be dominant in Canadian law. Now, as you've heard, this is the beginning of a conference at which there are a wonderful array of scholars, cleverer than I, who will be speaking in the course of the next 2 days. And one of those speakers is a former, much-loved colleague of ours, Ben Berger, who's now at Osgoode Hall Law School. And he's shown how religion is constructed as a matter of individual choice, as a private matter in Canadian constitutional law. It is that conception of religion, grounded in individual choice, that shapes the Supreme Court of Canada's interpretation of religious freedom. And he's also argued that that conception is in considerable tension with the way in which many believers look upon their religions. Many believers consider that in their religious life, they're under a set of obligations that is in some way imposed upon them, that controls them. Obligations imposed by the God and pursued and passed on within a religious community. The two conceptions are in disjunction. Moreover, Professor Berger argues that the law's view of religion exerts cultural pressure on religious traditions, tending to reshape them, or attempting to reshape them, to conform to an individual, choice-affirming, private model. Well, in this lecture, I want us to shift our angle of vision and to consider how issues of religious freedom and religious toleration might appear to be different if we consider religious traditions to be forms of government, to be systems of law. Indeed, I'll argue that that model accords better with many aspects of religious experience. And by taking those dimensions of religious experience seriously, we're able to imagine different ways, perhaps more effective ways, of constructing the relationship between religions and the state. Moreover, we may also see more clearly why some societies, China for example, have difficulty accepting religious practice that is not directed and controlled by the state. So my talk will go through the steps that you see on this slide. Now, I should say that I'm not claiming that religious belief is always best understood or best approached through the framework of seeing it as, seeing religions as being species of legal or governmental order. In fact, if you were to ask me about my own beliefs, I think you'd find that mine accorded with the more intensely personal paradigm of religious belief. To such an extent that I have to say that I sometimes wonder whether my daughters, one of whom is here today, really know what my religious commitments are or have a sense of their meaning to me. So I'm not putting forward the idea of religions as systems of law and systems of government as capturing everything there is to say about religion. In fact, I think it's important to realize just how amazingly diverse religious beliefs and practices are. They include belief in supernatural beings, structured forms of worship, bodies of knowledge, or at least claim knowledge, about the ultimate nature of existence. But they also involve moral injunctions, the observance of holy days, dietary rules, the requirement that one cuts one's hair, or that one refrains from cutting one's hair, forms of physical discipline or bodily mortification, the learning of a sacred language, the avoidance of interaction with people of another gender or caste, the custody and management of sacred places, pilgrimage, even sacred dance. And this amazing slide is, of course, of the Mevlevi order, a Sufi order for whom Sufi order in Central Turkey, for whom dance is part of their worship. In fact, there's often a tendency in the academic literature to try to domesticate religion, to turn them into just one thing, which can then be inserted into a convenient pigeonhole. For example, in much of that literature, religions are treated as though they were systems of moral instruction and moral control, which some of them are, to some extent. That is one dimension of what one finds in religions. Or they're treated as simply a cultural product, like a literary or a musical tradition, in a way that evacuates the supernatural claims of religion. Religion without the awkward presence of a god. And that, of course, will not do. Religions are unruly. They make claims and sanction practices that are awkward. And it seems to me that in our grappling with religion, questions of religion, religious accommodation, we have to come to terms with religions as we find them. We may on occasion believe we have to set our face against certain religious practices, refusing to accept them within our community. In fact, I do believe that there are some practices against which we should set our face. But we should do so only in full knowledge of what those practices are and why they should be suppressed. We should not simply define them out of the scope of religious accommodation. And, as I hope to show, one of the things that often characterizes religions, one of the very salient things, is that they operate as systems of law and governance. Now, this approach draws on the theory that's, or an approach to law that's often referred to as legal pluralism. And that body, that approach, that body of theory, draws our attention to the fact that in many social contexts, the law of the state is not the only operative legal order. Like it or not, there are other sets of rules that are operative. Sets of rules that have their origins in places other than the state, and that have their own mechanisms for inducing compliance. And, like any legal orders, they also need to have ways of coping with disagreement, with hammering out a common position in the face of conflicting interpretations. They also then need their own institutions and procedures for decision. One often sees a compound then of normative and institutional pluralism existing within the society but not deriving its sense of legitimacy and its source of rules from the state. Perhaps even seeking to sustain itself against the state. And of course, a classic example, familiar to us in this context, would be indigenous traditions of law and governance, which members of indigenous communities hold fast to and use to sustain themselves and order their communities within this context. And it's that kind of legal and governmental order that I suggest may be an issue in cases of religious accommodation. And thus the state is encountering, when it deals with religious traditions, another order of law with its own institutions of decision-making that issues from a source other than the state itself. And once again, I want to make clear that it's not true of all forms of religious experience, but as I would suggest, it is more prevalent than we might otherwise think. Now, the theory of legal pluralism does not itself say how non-state legal orders should relate to the state. In fact, it does not even say that the non-state orders should be respected, although the very fact of their persistence, often against real pressure, suggests that they have some hold on the societies concerned. At least in some way, non-state orders would seem to have shown their powers of adaptation and of staying power, even in the face of pressure. And indeed, states have often interacted with religious traditions in a wide range of ways. They've sometimes attempted simply to suppress them. More frequently, they've attempted to tame and contain them. They may have developed incentives for favored religions and disincentives for others. Or you see instances where they have selectively recognized certain practices of religions, but attempted to reform or suppress others. And indeed, sometimes, historically, very frequently, they've attempted to meld their authority with that of religious traditions, so that they gain the benefit of the support from adherents of that religion. And of course, the same goes from the other side. Those who play important roles in religious traditions have also played their own part in the attempt to define the relationship with the state. They too have attempted to argue for particular forms of accommodation, and they too, on occasion, have attempted to capture the instrumentalities of the state to their own objectives. So what I would like to suggest we see at times is an interaction then of somewhat competing entities, each attempting to advance its particular mode of social ordering in relation to the other. From the state's point of view then, religions often appear to be unruly in a second sense. Not only are they wildly various in the practices that they contain, but they also push back against state mechanisms of social ordering, often advancing their own contrasting, quite separate order, separate at least in where it draws its authority. They can appear then as competitors of the state in their assertion of norms of conduct, in their decision-making processes, in their sources of authority. Often, however, those assertions of counter-authority are not just assertions of the claims of conscience. Religions are not just unruly. They are, in fact, quite ruling. It's just that they assert their own separate orders of rules. In fact, that suggests, I think, though those of you who are much more expert than I am on this. Some of the reasons, perhaps, for the resistance of the Chinese government to religious freedom, especially their attempt to control religious administration, overseeing the selection of bishops in the state-controlled churches, or naming their own pension lama, for example, with an attempt consciously to reduce the claims of religions to the status of mere folklore. It's not merely a sense of them not getting the point regarding the demands of conscience. They're concerned precisely with the emergence of separate sources of legal and political authority. And it's on that ground that the process of accommodation is most tightly contested. Okay. So, how might one think of religious traditions as traditions of governance? In what ways do religions today assert autonomous governmental authority? Now, of course, they often have their own internal organizational governance, like corporations or like NGOs, and I'm not going to be focused so much on those questions, because as long as the governance remains limited to the management of the organizations of the religious entity, they can often be easily accommodated. I'm interested rather in when religious governance extends beyond the organizational structure, to enter into competition with, to double up with, or sometimes to complement broader functions that we tend to associate with government. Those functions can take various forms, and so that you don't think that I'm making my task too easy, I'll tend to take my examples from Canadian society, and I'll try not to reach too far back into history in the examples, because of course if one does that, one certainly sees the role of denominations, of religions, as institutions administering orders that are self-consciously thought of as legal orders. The canon law, for example, of the Catholic Church. Okay. Well, one way in which they do that, still, is through the provision of services. Religious organizations often provide services that we tend to think of as being quintessentially public, especially relief of poverty, education, the provision of health care. That certainly is true in recent history. In fact, not all that far back, in Quebec prior to the Quiet Revolution, the whole panoply of those social services was offered overwhelmingly through religious-specific organizations. But it's common even today in religiously affiliated hospitals, in social services agencies that have particular religious identities, in schools, private schools, universities that have self-conscious religious affiliations. And although one might think that there has been a tendency towards secularization, there is still a very strong acknowledgement of the public purposes served by precisely those institutions. Indeed, if anything, there has been an extension of greater public funding to, for example, private schools in Canada that have a religious affiliation in recent years. And indeed, although it tends to fade back into the background, the very fact of providing tax donations for tax deductions rather, for donations to religious charities is an acknowledgement of their public role. Because after all, one ends up paying, in some ways substituting for at least part of what would otherwise pay to support governmental services, the funding that you've given to the charity. And incidentally, that kind of extent of tax deduction is by no means universal. In Australia, for example, there is not the same kind of tax deductibility of donations to religious charities. This acceptance of institutional pluralism, the acknowledgement or the support for the social service role being played by religiously affiliated institutions, allows these services to incorporate elements of religiously based norms and to address the distinctive needs of religious communities. It also draws upon and mobilizes the distinctive ethics within particular religions, activating them for purposes of public provision. Norms, for example, of charity and altruism. And in doing so, they also enact, in microcosm, the relationship of mutual benefit between governors and the governed, on which many political theories of legitimacy are based. The provision of services not only benefits from the willing support and participation of members of the society, but those organizing the provision also benefit from the appearance of legitimacy that goes along with the furnishing of those kinds of social services. And in fact, not just in microcosm. One of the factors that has tended to be used to explain the consolidation of support for the Muslim Brotherhood, for example, in the Middle East, or its offshoots, such as Hamas, is precisely their engagement in the provision of social services, which has tended to build a relationship with the population that it is then transferred into power within the political institutions of the state itself. So one of the ways in which religious traditions engage in activities that seem to have the kind of quasi-public character we often associate with governmental provision is through the provision of services. Moreover, they also engage, though perhaps without such direct state sanction, in the governance of conduct directly of their adherents. That governance is certainly evident in cohesive religious communities, such as the Hutterites or the Old Order Mennonites. But it also continues to operate for other religions that are not so cohesive, or at least not so densely organized, in more restrictive contexts, and especially in areas of personal and family law, through the informal mechanisms for the policing of sexual morality, the prescription of forms of courtship and marriage, in attempting to secure the performance of familial obligations of its adherents, in access to divorce, where it can often be for a believer just as important to have access to a religious acceptance of the ending of one's marriage as it is to have access to the state's conferral of recognition on the ending of one's marriage. Now, many of these operate in Canadian societies in what is an ostensibly private realm, but they still have a real sense of binding force for the adherents of those religions. And for people who belong to those religions can feel much more like an interaction with the rules of a society. And of course, that kind of governing role is formalized in other societies, including one of the ones that's represented in this conference, in India, where personal law is relative to one's religious attachment. And so one has different orders of personal law depending upon the religion to which you belong. Or Israel might be another example of a contemporary state of which that is true. Now, I could go on to cite chapter and verse about other forms of entanglement between religions and activities that we tend to think of as governmental, turning especially to the way in which religious arguments and religious organizations play a role in the determination of the direction of the state itself as mechanisms of mobilization of support at election time or for particular policies, sources of ideas, sources of commitment in support of those ideas. And I won't take you through a long list of further examples. But what I will say is this. It's become an accepted truth in critical scholarship on the Constitution that the divide between a public and a private sphere is not natural or necessary. It's constructed through the state's recognition of a sphere that can be left to private action. It's constructed by those decisions. It's not something that has an ambiguous prior definition. Indeed, much of that critical scholarship is sought to pull things from the private into the public sphere and expose them to scrutiny and to potential reform. An attempt that's captured in the great feminist slogan, "The personal is the political." What that tells us, for our purposes tonight, is that the line between public and private is often more arbitrary, more open to question than much theory premised on the location of religion within an individual conscience tends to assume. And if that is the case, then one might, with the state and religious institutions each serving what might be seen as public or quasi-public roles, the structuring of their relationship, the definition of their autonomy, might also take more complex forms. And indeed, Rajat Bhargava, who's speaking at this conference, has, in wonderful ways, articulated the different forms that secularism takes in different societies, with the role of the state being defined differently in different societies, the extent of distance that exists between the state and religious communities. And in the Indian context, this is often meant intensive state involvement in reforming religiously sanctioned practices, especially practices within Hinduism, that are seen to have significant consequences on the quality of life within Indian society more generally, notably the caste system. And indeed, another of the speakers here, Rinku Lamba, has done wonderful work on liberal traditions within India, which see the essence of that tradition not in being state abstention, but in state engagement in the reform of practices, often grounded in religion, that are seen as being as requiring reform. So one sees then, when one takes the governmental role, the quasi-public role of religion seriously, that one might be dealing with a much more complicated process with many more possibilities open before one when attempting to define the relative role of religious and political institutions. Well, what about religions as languages of law? What you have here is a page from the Analects of Confucius. And I'm very grateful to Su Xianfei, who's visiting here from the Chinese Academy of Social Sciences, for actually helping me realize what the slide was actually saying. But as with a great many textual traditions, the sayings of Confucius provide the stimulus, the groundwork, for a rich interpretive tradition built around them. And so on this page, the large characters are the sayings of Confucius himself. And then the smaller characters are then the interpretation of those sayings. Starting, as often happens, with philological matters, the pronunciation of the characters, introducing the reader to characters that may be unfamiliar to the reader, but then moving on to an examination of the foundational meaning of the text. And now I could have provided in slide form examples from just about any other textual tradition I could have placed a page of the Talmud with its rich set of commentaries and commentaries upon commentaries. And I've in fact brought with me Gandhi's translation and commentary on the Bhagavad Gita. Indeed, one could do the same also with religious traditions that are not text-based, but that draw their sources from stories that are passed on orally. In fact, indeed, probably even more so, because the telling of a story often proceeds not just through repetition, but through explanations, adaptations, and variations. Now, what that tells us is that religious practice is not just a matter of obeying a set of requirements. It's very often a process of meditation, of reflection, of deliberation, of entering into a story or text, exploring its meaning, and attempting to determine how that meaning should be manifest in one's life. In the political theory literature, religion is often treated as though it were a matter of binding requirements, commands, issued by the religious authority to the believer, given by authority, and through which the believer's only legitimate response is to obey. If this is one's view of religion, then it does appear to be an impediment to reason and to deliberation. A believer's position is fixed by their faith. It's about authority and judgment, and it's highly resistant to reason criticism and reconsideration. Moreover, it will tend to make claims that are necessarily confined to believers, incapable of dialogue or debate across religious lines. And that, indeed, is the view of a number of contemporary liberal political philosophers. Notably, the American political philosopher John Rawls, who sees religious arguments as things that have to be kept out of the public sphere, precisely because they're necessarily partial in their appeal, of interest only to believers, incapable of providing the foundation for legitimate public action. But if one takes the view of religious reasoning that's represented by the image you have on the screen, the very heart of religious consideration consists of intensive engagement with an exploration of the religion's texts, an engagement that is concerned with how those lessons might shape one's conduct today, and that in that attempt to apply their lessons to today, they're necessarily critical. Indeed, there was a lecture sponsored by the Center for Studies in Religion and Society about a month ago by Andrew Rippon of this university. And he gave one example of the interpretive challenges within the Islamic tradition. And he quoted a provision, or a verse from the Quran that talks about one's parents growing old with one, still being around as they grow old with you. And it instructs children not to say fie unto them, nor to repulse them, but to speak to them a gracious word. And Andrew talked about the debates around the interpretation of that passage. Was the injunction limited to the use of the word fie? So that was the only thing, although in fact, actually, for us, it would only be the Arabic word that would be prohibited, if that were the view. Or is it about the expression of other forms of disrespect? Or is it about the substance of disrespect itself, regardless of its expression? And I can't see how, with any tradition, one can avoid engaging in a kind of intensive querying of the text and reflection upon its significance for you today that suggests. So rather than seeing religious traditions as highly definite commands, perhaps they're best seen as being more akin to languages of normative deliberation that have their own conceptual structure, that have their particular texts from which one argues within the tradition, and which give structure to one's inquiry. That consists of histories of religious practice, past questioning, past answers that have been given, upon which one reflects in attempting to determine how to fashion where we should go on from here. Those languages of religious deliberation certainly have their dispositions built into them, but those dispositions are then subject to deliberation. Now, if that's right, this means that the structures of deliberation, the ways in which discordant interpretations are considered and settled, the processes of determination become crucial. Religious traditions are not then just structures of command, but structures of debate, deliberation, and decision, very much like other legal traditions with which we're familiar. It also means that religious arguments are not as hermetically sealed as some political theorists would assume. It's possible to enter into another's language, read their text, become familiar with their practices, and to reason back to one's own commitments by a process of translation. Now, one may never have the same position with respect to those texts as a believer, and in fact, I think it's a great mistake to think that the interpretation then can take the place and exhaust the capacity, the relationship to the text. But there are definitely ways to begin to engage in meaningful conversation across religious traditions that draw directly on religious sources. And this suggests that the task of religious accommodation is not just a matter of allowing one the privacy of one's own conscience. It may be best conceived in jurisdictional terms, in making room for those languages of discussion and deliberation, and allowing space for the processes of decision to exist. The fundamental model of institutional, maybe one of institutional coexistence and adjustment, not merely the allowance or not of a zone of individual autonomy. And the best constitutional model may not then be one of rights, of a claim against the state, but rather it may be some form of federal arrangement where each has its own particular jurisdiction. Now, this is a slide of the gates side by side of a Buddhist temple and a Taoist temple in Baoshan, China. Now, if we see the challenge of religious accommodation in this light, we may approach it in very different ways. We may see the need to accommodate institutional structures and attend to precisely what institution we are recognizing. In fact, it's often the case in colonial contexts or in colonial contexts, it was not uncommon to recognize the law of particular religious communities, but not the institutions that had custody of that law, at least not in their original complexity. So what one ends up recognizing is a simplified, stripped down, often quite conservative conception of the religious tradition, without the mechanisms of discussion and without the mechanisms of change that originally existed. As Verinda Narayan, for example, has argued with respect to the recognition of Muslim customary law, Muslim personal law, within the Indian context during the colonial period. So the first thing is we may, in fact, decide that we need to accommodate institutional structures and attend to the nature of those institutions. We may also attend to the breadth of representation that exists. within those institutions, not allowing them to overclaim adherence of members of that religious tradition. We may focus on points of interconnection across the faiths or across faith and government. The Muslim councils, for example, that were newly valorized as agents of consultation in a number of European countries when Islamic fundamentalist terrorism became an acute issue. And we may cherish the possibility of building deliberation across those institutions. And let me give you a practical example of how the form of accommodation may look somewhat different, the form of engagement may look somewhat different. In 2004, an organization calling itself the Islamic Institute of Civil Justice was created in Ontario, and it sought to use the Arbitration Act, which is a general scheme that allows for the resolution of disputes by private arbitrators, and then with those resolutions ultimately being enforceable after the fact, of using the Arbitration Act as a way of settling certain family disputes in a way that could draw upon Sharia law. In fact, there had been religious communities that were already using the Arbitration Act for similar purposes. It was being used by some Jewish groups and by some Christian denominations. The former Attorney General of Ontario, Marion Boyd, was asked to inquire into this possibility and report upon it. And so in December 2004, she delivered her report. And she suggested that, in fact, this go-ahead, under special terms that we elaborated, that would allow, for example, for the training of the arbitrators so that they had some claim to expertise in the tradition, record keeping, publicity of the awards that were made, procedures for informing parties of their rights and for assuring themselves that the participation was voluntary, and also giving rise to a series of processes of review of arbitration awards that were given under the system. And there was an outcry in response to her report. Suggestion that this was introducing Sharia law in a manner that could very well be at variance from Canadian law, and that this was something that just was reprehensible and should not occur. But here's the thing. It's not as though issues of family breakup are always settled by the courts. In fact, the vast majority of them are settled by informal negotiations and by informal agreements. And in that highly private context, shielded from view, certainly it's very possible, in fact it's a certainty, that religious and cultural traditions continue to play a role. It's not as though the influence of these traditions is something that's created by the state. It's something that has hold within the particular communities of adherents themselves. And the outcome of banning the use of the arbitration process did nothing to stop that from happening. What it did do is make it invisible. If the scheme had come to creation, as it would have been envisaged in the Boyd report, we would have had a visible, deliberative process with a series of controls put in place, exposed to public commentary, that would have fostered the deliberative process around the role of these norms and contemporary interpretations of Sharia, rather than having them continue in a fashion that is not good, that had no such processes of deliberation and reform. So if we take the governmental and legal character seriously of religious traditions, we may come up with solutions that are quite different and perhaps even better adapted to the challenges in which one finds ourselves. Well, to this point you may think that you've been the subject of a typical lawyer's maneuver. Taken something that is often discussed in substantive terms, where people care deeply about substantive commitments, and I've turned it into a question of procedure, to a system of legal order with systems of deliberation that can be structured by recognizing different religious jurisdictions, and the substance has fallen out of the argument. This, of course, is a painting by William Blake, and it captures the sense of revelation bursting in upon our normal lives. Because, of course, if there's one thing that is true of religions, is that they're not just about procedures of deliberation. They involve strenuous, deeply felt claims of truth, and a concern with the capacity to be able to make claims of truth that go far and way beyond the normal processes of discussion or deliberation about the views that we might just happen to have, which puts religious interpretation into a somewhat different game, where there's a special obligation of fidelity to the text, and especially an openness to being told off, right? To having one's conduct judged wanting, and to be told that it has to cease. So maybe religions are then a little more unruly than I've been letting on. So what can one say? Well, yes, there are things in religious traditions that cannot be domesticated, and that will always cause non-believers trouble. Things grounded in different metaphysics, in different standards of proof. But I'm struck by the fact that that there are debates in the political theoretical literature that deal with similar challenges, that recognize that prior rules cannot decide all. Indeed, if they do attempt to decide everything through nicely contained structures of rules and principles, they may end up cutting off the very essence of political agency. Now, a lot of political theorists who are troubled by this question tend to take their inspiration by a very controversial figure, Carl Schmitt, Nazi political theorist, referred to as the crown jurist of the Nazi regime. And I have to say that I myself have a complicated relationship with Schmitt. For me, grappling with Schmitt's work is a little bit like staring the devil in the face. You realize that he's gone badly off the rails, but you want to know why. Because he's got his hooks into you somehow, and you have to come to terms with it. And there are theorists who have attempted to grapple with these arguments, and have done so in ways that reveal their implications or explore their implications in ways that I find more productive than Schmitt's own work. Paul Kahn's work, for example, the work of Martin Laughlin, who will be speaking actually a week from tomorrow here on this university, or my colleague Ben Berger as well, who also has tangled with Schmitt. Where there is this commitment to preserving the valuing of agency. And of course, there's a very practical dimension in our political life. It's exactly those kinds of strong claims of truth, those unruly, undomesticated claims of truth, that are often the drivers of fundamental political change. Those of you who know China will know much better than me the debate that exists within China about the extent to which religious communities are in many ways some of the, if you look at the vanguard of unsettling the regime in China, precisely because they make these strong claims of truth and of value. It's an interesting case. China attempts the Chinese government has attempted to approach religions as though there were species of folklore. To what extent is that just one example of the attempt to monopolize the judgments of political truth within that society, so that the whole society is folklorized without significant impact for political debates within China more generally? Now, my own sense is that participatory political institutions, that this should not be seen as something that's in tension with the emphasis on process and deliberative institutions that I sketched before, but that participatory political institutions are often the best way to respond to that drive. The orderly creation of a public voice in a way that is truly participatory and therefore has claims to true representativeness. So for me, this chain of reasoning does lead back to processes of deliberation and institutions of decision, but in a way that recognizes that one is working across different legal and governmental institutions, each with their claims. But one may have to realize that engaging in that process of institutional structuring, one may well encounter at repeated places, yet again, the unruly character of religions. And that may not be such a bad thing. Thanks very much.